All right. Hello, everybody. As you heard, I have COVID. There's COVID running through my house right now. And so I'm really not feeling up to doing a Zoom class for tomorrow. So I'm going to just do a quick lecture on Chapter 2 in the Employment Law textbook. So let me maneuver a couple of things here. All right. Chapter 2 is titled Employment Contracts and Wrongful Discharge. And first thing that's well, the book says that this area of the law is where federal and state legislatures have not fully populated the field with statutes. Therefore, the courts are still, by and large, sovereign. This type of law is referred to as common law. If you had me for business law, you know that we talked about common law quite a bit. This is the law that is either of tradition or history, and so therefore employment has a lot to do with common law. All right, so the first thing we want to talk about is employment at will. And most states are employment at will states. Employment at will means that both the employee and the employer are free to unilaterally terminate the relationship at any time and for any legally permissible reason or for no reason at all. Now, the way that I look at this, I always say that this means that I can end your employment, I can terminate your employment for no reason, for any reason, as long as it's not the wrong reason. Okay, so in this chapter, they're going to talk about public policy and why you can't be fired if it's against public policy. And yes, I agree with that. That's what I refer to as illegal reasons. Okay, so, but the reality of it is I can let you go. I can fire you for any reason or no reason. Hi, good morning. I'm glad you came into work today. You're fired. Why? I just decided I don't want to have you as an employee anymore. I'm allowed to do that? Yep. You're an at-will employee. I can fire you for no reason. Or here's a reason. I don't like the fact that you wore brown shoes today. I really, really hate that people wear brown shoes. So you're fired. Well, I didn't know I wasn't allowed to wear brown shoes. Too bad. Too bad. You should have known. Well, that's just not fair. Who said life was fair? Am I allowed to do that? The answer is yes, I am. Okay. According to the book, in the 19th century, virtually every state court subscribed to the doctrine of employment at will. In this raw form, employment at will holds that an employee who has not been hired for an express period of time, say a year, can be fired at any time for any reason or no reason. Okay, now there have been laws that have cut into this. For example, the National Labor Relations Act talks about the process of forming a union for collective bargaining. So if you are a person that are engaging in the process of trying to get a union involved with where you work, you are theoretically protected and not allowed to be fired for that reason. Title VII of the Civil Rights Act forbids discharge on the basis of race, color, gender, creed, or national origin. The Age Discrimination of Employment Act prohibits older workers from being discriminatorily discharged. And old means 40, by the way. OSHA makes it illegal to fire an employee in retaliation for filing a safety complaint. So there are some rules out there that say, no, you're not allowed to be fired for these reasons. All right, we're going to refer to those. The book refers to those as public policy reasons. I'll refer to those as the illegal reasons. Okay, so you're not allowed to do that. Still, that leaves a large area of discretion for private sector employees who can discharge at will. There's no federal law that outlaws workplace discrimination on the basis of sexual orientation. That's sort of up in the air. I know that there's a lot of things that have gone back and forth on that. I'm not sure what the actual current status of that is, but do understand that states and local governments have gotten into the area of talking about sexual orientation and such. I will tell you that I am absolutely positive where I live up in Erie County that there is a county ordinance that makes it illegal to discriminate based on sexual orientation. So understand you really need to look into what's going on. 2014, Obama issued an executive order prohibiting federal government contractors, people that deal with the federal government, from discriminating based on sexual orientation. Another category of people out here who should be protected are what are called whistleblowers. These are employees who report or attempt to report employer wrongdoing, actions threatening public health or safety to governmental authorities. So if I'm a whistleblower, if I am seeing that my company is falsifying its records and not putting together all of its pollution controls properly. We're not doing our reporting properly. We're cheating, and I turn the company in to the government. Obviously, my boss is going to be mad about that. The owner is going to be mad about that. The entire company is going to be mad about that. But in theory, I'm a whistleblower, and I was just doing what was required under the law, and I should be protected from retaliation. That's the whistleblower portion of enforcement acts. Advocates of the employee at will doctrine defend it by pointing out that the employee is likewise free to sever the working relationship at any time, and it's a free market. The worker with sufficient bargaining power can demand an employment contract for a set period of time if so desired. Okay, but a lot of people are just not in that powerful of a position. So in reality, the only way for most people, the only way to have the ability to be protected in their employment is through unionization. Now, once a union is in place, then it's not necessarily going to be the law that works to protect you, but it'll be the collective bargaining agent and the protection of the union itself. All right, so the book talks about wrongful discharge based on public policy. The most commonly adopted exemption to pure employment at will is the public policy exemption. If a statute creates a right or a duty for the employee, he or she may not be fired for exercising that legal right or fulfilling that legal duty. The example that the book uses is jury duty. Okay, so you receive a summons in the mail that you are to report for jury duty. You go to your boss and say, I need to have Thursday off because I have to report for jury duty. Your boss says, if you go, don't bother coming into work on Friday because you're fired. Okay, now I know that in Pennsylvania, there is a law that protects your rights, that you cannot be fired for going to jury duty, although there is nothing that protects your pay. There's nothing that says the employer has to pay you, but you are not allowed to be fired. Okay, so that's another one of these places where the public policy is going to say, no, you're not allowed to be fired, even if this is an at-will employment state. Okay. Additionally, if the statute itself provides the employee with a cause of action, the courts are reluctant to recognize an additional form of cause of action by allowing you into courts. Pennsylvania courts agree that an employee fired on the basis of a gender of race discrimination in Pennsylvania should resort to the exclusive remedy of the Pennsylvania Human Relations Act, which enforces the Equal Employment EEOC, Equal Employment Opportunity Act, EEOA. requires that the employee initially seek redress with the commission created by the act. If the employee fails to act with the commission, thus losing the right of action under the Pennsylvania Human Relations Act, that person cannot then come to court with the same grievances claiming that he was wrongfully discharged. So you have in Pennsylvania the requirement to go through the Pennsylvania Human Relations Commission. California is exactly different. California creates a tort under its act so that you can sue under for wrongful termination. There's a huge case here about the California decision regarding that. I'm not going to go over that on video here. So the first section, the things we're supposed to have learned. The justifications for at-will employment is freedom of contract, free enterprise in a competitive marketplace. Problems with at-will, disparities in bargaining power, and potential for unfair treatment falling outside of protect. Exceptions to at-will, statutory exceptions such as anti-discrimination laws, employment contracts that set specific lengths of employment, and public policy exemptions. So express and implied contracts of employment. So in business law, we talked about that just about everything in business involves a contract. And I believe that the employment relationship itself is a contract, okay? But it's not a contract that has a particular right to be enforced for a particular period of time, at least not in its general form. Okay, so if you go and ask for a job at Walmart, you get a interview, they decide to hire you as a cashier, they train you as a cashier, they give you your uniform, they give you your rate of pay, and they tell you when to start working. That's a contractual relationship. You're going to trade them your hours for money. However, I don't think you have any expectation that you're entitled to that job as we move forward into the future, right? There's no guarantee that the job is yours forever, right? There's an expectation that if you do your job, you probably won't get fired. No guarantee. Excuse me. Can you have a contract that guarantees you employment for a period of time? And the answer to that is yes. If you are a particularly skilled employee or necessary or helpful or useful or indispensable employee, they may want to get into a contract where neither party has the ability to leave for a particular period of time. So, is that possible? Absolutely. You know, I have the Gamalchak Widgets decides that John Smith is the best widget salesman in the world, and I go and hire him away from my competitor, and I guarantee him a contract of employment for X number of years. Let's say 2 years. I want to make it longer than a year. So if I give him a contract for 2 years, I'm going to give him $100,000 a year per year for a 2-year period, plus a certain percentage of sales as a commission. Okay, so he's going to be a very well-paid employee, but I have him guaranteed for 2 years. He's not allowed to just quit, but I'm also not allowed to just fire. Now, in the contract, we may have some escape provisions. For example, I may have the ability to fire him if he does not meet certain quotas or goals, sales goals, that type of thing. I could probably fire him for cause, which would be stealing from me or committing a crime or getting the company in trouble with the government for doing something illegal. But the reality of it is it's no longer, if I have a contract for a specific period of time, then it's no longer employment at will. It's a different thing. Okay. And the book talks about express contracts and implied contracts. Express contract is control over which the terms are explicitly stated, usually in writing, but perhaps only verbally. Often in great detail, In interpreting such a contract, the judge and or the jury is asked only to determine what the explicit terms are and to interpret them according to their plain meaning. An implied contract is a contract relationship, the terms and conditions which must be inferred by the contracting party's behavior. Okay, so explicit contract, it's generally going to be in writing. An implied contract can never be in writing, right? Because if it was in writing, it would be an explicit contract. Now, where do you see implied contracts? Well, you see implied contracts, at least the claim of implied contracts, when you have somebody who says, oh, no, you're not allowed to fire me because I read this in the employee handbook. Now, one of the things that you should have as an employer is an employee handbook. The employee handbook, when we were talking about unemployment, for example, remember I said that you could avoid paying the person unemployment compensation or benefits if he was released or separated from employment for willful misconduct. Now, willful misconduct means that the person willfully and voluntarily broke a company rule, and then you followed a procedure to have him removed or terminated or at least disciplined. Well, how do they know what the rules are? Generally, it's because you, as an employer, were smart enough to create an employee handbook. And in that handbook, you have all of the rules regarding their employment. How many times they're allowed to be late, how many vacation days they get, how many sick days they get, what happens if they miss too many days, what happens if they have to go on maternity leave or medical leave. Are you subject to the terms of the family leave, family FMLA, the Family Medical Leave Act, those types of things should all be in an employee handbook. That way, if they do something wrong, they know what the rule was. When you go to fight their unemployment, you can say willful misconduct. They know what the rule was, and they broke the rule X number of times. Here's the proof of all of that stuff, including you would give the judge, the referee, a copy of the handbook. One of the problems you get into is that many employees out there will then say that the handbook, the employee handbook, is a contract and it gives them certain rights. If a company provides its employees with a personnel handbook, and a handbook says the employees will be fired only for certain enumerated infractions of work rules, or as the firm will follow certain procedures in disciplining them, a worker may later argue that the manual formed a part of his or her employment contract with the firm. An increasing number of state and federal courts are agreeing with that argument. Many employers in return have responded by adding clauses to their employee handbooks that reserves the firm's right to make unilateral changes or to vary the application of particular policies to fit the unique circumstances of every new situation. You will almost always see the language in the employee handbook that says the terms and clauses or phrases or procedures or whatever included in this handbook are not a contract of employment. So you'll see a disclaimer in there from the employer that is smart enough to realize that the employees are going to start trying to use that as an employment contract against them. The book has 3 cases that court cases that we could read. We may read at some point, but not for the purposes of this video. The cases indicate that the employer retains considerable control over the terms of the employment relationship, but it's not unlimited. While an employer, for example, may exercise discretion in its disciplinary procedures, this discretion is not unlimited. Furthermore, changes in the fundamental term of employment, such as compensation, when contractually set, cannot be arbitrarily modified. So what I think is going to happen out of this, I think the way that you can read the state of the law out there right now is that more and more courts are going to look at what is in the employee handbook, and if there are guarantees given by the employer to the employee, then the court will look at those as being enforceable agreements or portions of the agreement between the employer and the employee. So you have to be very careful what you put in your employment contract. I don't think you should ever put in your employment contract that the person is guaranteed their job unless they are able to be removed for cause. Cause is where they have done something wrong under a specific set of rules as to what you define as being cause, stealing, damaging property. You can have your definition of what cause is. But then if you put that in the handbook, all you're doing is giving control and or rights to the employees. Well, if you want to do that and be a really nice guy, that's great, but you're really handcuffing yourself as a manager. What happens if you have to let somebody go because of financial problems? You can't keep anybody on because you don't have any sales, so you want to lay your employees off. Be very careful what you put in your employee handbook. I think that the courts, if they find those types of things, they'll enforce them. But what I believe is that what's going to happen is if you say that a discipline policy is going to be implemented in the following manner, and there's a 3-step process or a 4-step process or whatever you define as your disciplinary process, follow that. If you don't follow that, then you're going to end up with the courts saying that you broke some sort of an agreement with the employee, even though there's no contractual relationship for it to continue on for an unlimited period of time, blah, blah, blah. But if you didn't follow the procedures properly, the courts are probably going to come down on you for that. So don't put yourself into a corner by giving your employees too many rights. And then and I think you should have a procedure with how you get into the disciplining of your employees. Follow it for everybody, because once again, if you follow the rule for certain types of employees but don't bother enforcing those rules for a different type of employee, then you're going to end up with a lawsuit for some sort of discrimination, because they're going to find that there's some sort of a grouping that is going to be in violation of the Civil Rights Act or something. The book talks about the Model Employment Termination Act. The National Conference of Commissioners of Uniform State Laws was organized in the 1890s as part of a movement in the American Bar Association for the reform and unification of American law. Currently, the conference's list comprises 99 unified acts and 24 model acts. Uniform. Okay, we talked about uniformity. There's certain types of uniforms laws out there. If you had me for business law, we talked about the Uniform Commercial Code. That came from this group. Okay, this part of the chapter is talking about the Model Employment Termination Act. It does not say unified or uniform employment termination act, because this law is not in widespread use. This is something that's being suggested. It's something that's been researched and designed by this uniform law group, the National Conference on Commissioners for Uniform State Laws. But very few states have adopted anything like this. I'm not saying it doesn't exist in the law out there anywhere, but it is not the majority. Okay, they established something called the Model Act, the Model Employment Termination Act. This law states that an employer may not terminate the employment of an employee without good cause. Now, the statute goes on to talk about good cause in 2 ways. The first is the employee's inadequate or improper conduct in performing the job. The second is the economic or institutional goals of the employer. So if I run out of money and I can't pay you, that's a good cause to let you go. So it doesn't seem, although we're getting pretty far away from the actual at-will employment, oh, you wore brown shoes, you're fired. I don't know how many people actually do stupid things like that with their employees. If you have a good employee, you tend to want them to stay and work for you. If you don't have the money to pay for them, you want to let them go so they can find better employment, those types of things. I don't see a whole lot of problem with this, but once again, not really in widespread usage. If employment is terminated without good cause, the Model Act provides for remedies, reinstatement, back pay, lost benefits, lump sum service payments, and attorney fees can be recovered. Enforcement is done solely by arbitration, not through the court system. So anyhow, once again, that's the Model Employment Termination Act. Take it for what it's worth. It's out there. Who knows? Someday there may be some huge wave of need for that to be passed, and it may become hot, and it might end up getting passed by the many states. Not today. The summary of this particular section in the book: contracts and handbooks. Common law presumption of at-will employment can be overcome by express contract or implication. For example, a policy in the employee handbook. American courts remain reluctant to infer terms and conditions of employment when the employer has not expressly awarded the right to its employees. So the courts are not looking to create long-term employment contracts unless they see it in an explicit contract generally. Protection for whistleblowers. One of the problems with whistleblower protection is the various laws that are out there that theoretically protect whistleblowers. They may not have any teeth. They may say that the employee is not to be retaliated against, and they may give a whole list of things that the employer is not allowed to do if the employee turned them in for some violation of some rule or a crime or something. But the whistleblower section of the act may not say what's supposed to happen. It may not create any remedy for the employee. And although it says they're not supposed to be retaliated against, they may end up getting retaliated against, lose their job, lose their pay, various things, and not have any recourse. We have the Sarbanes-Oxley Act out there, July 30th, 2020. This is passed in reaction to all of the accounting scandals that had happened in the late 1990s, Enron being the top one that's out there. It does a lot of things with regard to accounting and disclosure requirements and SEC filings and things like that. But in addition, it has a whistleblower section. The interesting thing about the Sarbanes-Oxley Act and its whistleblower, SOX includes two provisions, one criminal and the other civil, for the protection of employees who report improper conduct by corporations, by corporate officials concerning securities fraud and corruptions. Dozens of federal laws, such as OSHA, protect employees who blow the whistles. Perhaps the scariest aspect of SOX's criminal provision is that it can be used to punish retaliation against persons who provide information to law enforcement officials relating to the possible commission of any federal offense, not just securities fraud. Okay, although Sarbanes-Oxley is pointed to specifically securities fraud, the whistleblower section here creates criminal punishment for companies that punish whistleblowers for any reporting of any federal criminal activity. Okay, so it's a very broad application of Sarbanes-Oxley's whistleblower protections. The civil liability under Sarbanes-Oxley, Child of corporate greed and accounting scandals, SOX's legislative history indicates that its whistleblower provisions are intended primarily to protect employees of publicly traded companies acting in the public interest to try to prevent officer director wrongdoing and to encourage and protect those who report fraudulent activity that can damage innocent investors in publicly traded companies. So the civil liability section here is out there, so you can bring some lawsuits if you are your discipline's not the word I'm looking for. If you are abused for being a whistleblower, but it does seem that the civil side of this is limited to the securities things. Okay. A whistleblower is an employee who calls attention to the employer's illegal or unethical activities. Many federal and state statutes seek to protect whistleblowers by making retaliation an illegal act. The most significant whistleblower protection of the 21st century is the Sarbanes-Oxley Act, which protects employees who blow the whistle on illegal financial transactions. Whistleblowers' rights may conflict with the privacy rights of others. All right. So just looking at a summary of that, that's the end of what I pulled out of the chapter. Like I said, we may go back in and look at the cases that are in the chapter because a good half of the chapter were the court cases. But just a summary at the end of the chapter. At-will doctrine holds that unless the parties expressly agree on a specific duration, the employment may be severed by either party at any time. There are common law exceptions to the at-will employment. A clear mandate of public policy, such as jury duty, will eliminate your ability to fire somebody. We have the other things that are out there under the protections of the Civil Rights Act. So if you can't do it for gender, national heritage, religion, those types of things. Remember that we talk about the employment contract that can last for a specific period of time. Generally, it's going to be a contract that is an express contract. Implied contracts are going to be things that you're going to be, the employee is going to be trying to pull out of the employee handbook. There's a doctrine of good faith and fair dealing, but only a very small minority of American states use this, which is where a terminated worker may bring a wrongful discharge action whenever the employer has failed to deal in good faith. If an employer fires a salesman purely because he doesn't want to make the payments for his commissions, that would be bad faith, and he could sue for wrongful discharge. Very small minority of states could you do that. Certainly, you could sue under agency law for the commissions that you were due. You'd have to prove that they were due to you. We talked about the Model Employment Termination Act. Only a handful of states. And finally, the federal Sarbanes-Oxley Act of 2002, excuse me, makes such retaliation against those reporting a federal crime itself that can result in imprisonment of corporate officers. So, all right, that's really all I wanted to really get out of Chapter 2. It's a discussion about employment contracts and employment at will and the various pieces of the law or tradition that have cut into employment at will. It's still out there. It's still the majority of the law of the majority of the land out there. But understand it does have its limitations. We can't just, hey, I'm firing you today because you wore brown shoes. Yep, I can do that. Hey, I'm firing you today because you have brown skin. No, I can't do that. Okay, understand. That's all I've got. The reality is I don't expect to be on campus again on Thursday, so expect that I'll probably just be on Zoom. Watch your emails to see what's going to be happening. I'll try to give you plenty of advance notice as to what is going on and when it's going on and where it's going on. So, well, that's all I have for today. Ta-ta for now. We'll see you later.